my counterclaims.
Okay.
Okay. Mr. Stewart, can you hear me?
Yes, ma'am.
Okay. So let's talk about the damages that you are asking for in this case. You are asking for $14,500. Is that correct?
Yes, ma'am.
Okay. And how did you arrive at that figure?
Well, just about what I thought through experience and training would have cost to put that back together again.
And what experience and training are you referring to?
Life skills, I've owned houses before.
Okay.
I've fixed houses.
Okay. Do you have
do all kinds of things. We don't make a lot of money.
Okay, do you have any invoices or receipts from a contractor to support that number?
No,
Okay. Have you expended any of those costs as of today, $14,500?
yes,
And how much have you spent to date to make the repairs?
right around 5,000.
Okay. Do you have evidence that you paid that $5,000 to make repairs?
Or
I'm sorry, what was that, Mr. Stewart?
yes,
Okay, do you have that evidence with you here today?
They'll send the invoices over following their bank statements. So it's not something we would like to put on the screen.
Okay. All right. Okay, so earlier in your testimony today, you talked about Clayton County Code Enforcement. When approximately did they contact you regarding the property?
well, I've met them.
Here. August 13th, we have the letter.
August 13th, we got the letter.
Okay. Did you receive any fines from Clayton County Code Enforcement?
Any fines, ma'am?
Yes, any fines?
No.
Okay. Do you recall having a conversation with the defendants about filing this lawsuit?
No,
Okay. Do you recall a conversation where Jasmine Hill asked you why you filed this lawsuit?
no,
Isn't it true that you told Jasmine Hill that you filed this lawsuit because of the Clayton County Code Enforcement complaint?
no.
I have nothing further, Your Honor.
Thank you. Mr. or Mrs. Stewart, do you have any other evidence to put on based upon this claim?
Sure.
I'm going to pull up pictures of some of the damage in support of their claim. I can't share my screen because the host disabled screen sharing.
Yes, Miss Vega. To show evidence of the damage to the home, there's first a hurdle to show that there is liability on behalf of the defendant, and I haven't heard that yet.
Okay.
I've heard that there is a lease purchase agreement entered into in 2017. The home was still owned by the Stewarts, and the Stewarts didn't take advantage of the opportunity the law gives for landlords to go and inspect their property to make certain that a water heater has been leaking for 4 years. What I've heard is generalities, assumptions. It must be this because it couldn't be that. I have not heard evidence to support their claim. So I don't need to see the pictures. I take it at the word that there is damage done to the house. The heart of the matter is what steps did the landlord take to prevent the tenant from damaging the home? So let's assume that the water heater was leaking for 4 years, but Mr. Stewart did not take any steps to go and inspect his property to make sure that it's not getting damaged. My understanding of the state of the law is that if under his belief, the property, the water heater was leaking for 4 years, and he had the right to go on that property in 1 month and check to see if anything was going wrong, and he chose not to do that, I can't hold that against the defendants.
Okay, thank you. Did you guys understand?
Mhm.
So, Ms. Edmonds, you don't have to put on any evidence. Unless I hear more, I haven't found that the plaintiff has put enough evidence forward for me to even switch over to the defense and have them explain. So I'm going to dismiss or deny their claim. Now we're going to get to the counterclaim. I understand that, and correct me if I'm wrong, Ms. Edmonds is putting on a counterclaim and Ms. Vega is defending the counterclaim.
Yes, sir, that's correct.
Okay. Ms. Edmonds, I'm going to hear from you as it relates to your counterclaim.
Thank you, Your Honor. I would like to start with my client, Ms. Hill.
And Ms. Edmonds, would you give me just a thumbnail sketch of what your claim relates to?
Sure, Your
and
Honor.
what you expect the evidence to show?
Yes, Your Honor. This is a case about retaliation. The evidence in this case will show that my clients, Jasmine and Latoya Hill, entered into a lease with the option to purchase in November of 2017. In 2021, the landlord-tenant relationship took a turn for the worse when the single-family home became plagued with electrical, plumbing, mold, compromised flooring, and other issues. After requesting repairs over 10 times and calling Clayton County Code Enforcement, Anthony and Penelope Stewart retaliated against my clients by filing this lawsuit. The evidence will show that because the plaintiff's refusal to make repairs, my clients incurred out-of-pocket costs as well as attorney's fees. The evidence will show that the issues with the property were not created by my client's actions or purported negligence. The evidence will show that the plaintiff's misunderstandings of Georgia law and their delay in making repairs was the sole cause of the issues with the electrical, plumbing, and flooring issues. My clients are requesting make-whole relief based on the Stewart's breach of contract, retaliation, and their intentional failure to repair the property.
So let me ask you this, Ms. Edmonds, before we go down this long winding road. Your clients lived in the property since 2017, correct?
Correct, Your Honor.
Did your clients have the ability to leave the property?
Yes, Your Honor, they could have terminated the lease.
And they chose not to?
Yes, Your Honor. To clarify, Your Honor, the issues really began in March of 2021. The entire, 4 years that they were living there, they weren't having issues. The issues with the electrical and the issues with the water heater bursting, all of that happened last year. So it wasn't as if they were having these issues ongoing for the entire tenancy.
So let me ask you this question. This is a lease purchase agreement where your clients eventually intended to own this property.
Originally, yes, Your Honor.
And as things started to, let's say it was in 2021, things started to go bad, or the house became, and I'm not going to use the term unlivable, but the house became a problem. Anyone that owns a home knows that there has to be regular maintenance to the home, or the house will go down. Are you going to be able to show me that your clients took reasonable steps to make repairs to any portion of the property?
Yes, Your Honor. I mean, my clients notified the plaintiffs in this case, like I said, over 15 times. There was a bit of a dispute between the tenants and the landlords because the landlords believed that they weren't responsible for repairs because of the lease with the option to purchase. But that's, as you've already stated, Your Honor, not the law in Georgia.
Given that they were making these statements as it relates to the house needing to be repaired, did they ever expend any funds to make repairs to any part of the property?
Yes, Your Honor. My clients hired a plumber to come out and do some investigative work to try and determine where the leak was coming from. They also spent out-of-pocket costs to try and fix some of the issues with the home.
Did they present those costs to the stewards to have them to pay those costs?
My clients did share with them that they paid costs out of pocket. I don't believe they asked for reimbursement. Again, Your Honor, the landlords repeatedly said, hey, it's at least with the option to purchase. It's your responsibility. And we have the evidence to support that as well.
Is that evidence in excess of the $5,000 stewards had to spend with the code enforcement issues?
As far as their out-of-pocket costs, Your Honor?
Yes, ma'am.
Their out-of-pocket costs weren't in excess of $5,000, but when you add their out-of-pocket costs with their attorney's fees, it is in excess of $5,000.
Okay. Before I let you finish, I'm going to have a brief conversation with Ms. Vega. And this is the reason why I encourage people to have a conversation before having a trial. Ms. Vega, you've heard Ms. Edmonds' brief explanation. What is your position? Briefly.
Our position on the counterclaims is that none of them are actually viable because for the failure to repair claim, we weren't ever presented with evidence of any damages as a result of that. They did allege that as a result of the rotted wood that her son fell through the stairs. However, they never notified the stewards that anything was wrong with the stairs. So the landlord's duty to repair is triggered by notice. And we were never presented with any medical bills for the care of the son. Because this is a minor child not named in the lawsuit, they can't recover for his pain and suffering. For the breach of contract claims, where they're alleging that the stewards failed to give them notice, the contract in paragraph 15 says that notice is only required if the stewards wanted to terminate their rights under the lease. No notice is required for the stewards to recoup their expenses that they feel are rightfully owed to them in court. And as for the other provision, PF1, that they're saying was breached, the stewards or the tenants aren't going to buy the home anyway. So that's a moot point at this juncture. And then for the retaliation claim, they simply haven't put forth evidence that this is retaliatory. She just testified that the stewards actually believe the responsibility for repairs was on the tenant. So they're here today because they actually believe that and they wanted to recoup the monies that they had to pay.
Ms. Edmonds, that's basically what I've heard so far. Is there anything different that you have to present?
So, excuse me, yes, Your Honor. So, I mean, we have extensive communications and email and text to prove that my clients provided notice with the failure to repair these issues. And we also will be calling a plumbing technician that they hired to come out to the home that proves that their negligence is not what caused the damages to the property. We've submitted on Thursday, Your Honor, to the clerk, all of our evidence for this case to make sure that you had it in time pursuant to the 72-hour rule. So we have a wealth of evidence to present in our case to prove that this was retaliatory. This entire lawsuit was retaliatory. And my client will testify that Mr. Stewart actually told her he filed this lawsuit because of the Clayton County Code Enforcement complaint that they filed against him when he failed to make repairs to the home.
Okay. Under the Landlord Tenant Law, Ms. Edmonds, are you familiar with Landlord Tenant Law?
Yes, Your Honor.
If a tenant believes that there is an issue as it relates to the property, that it needs to get repaired, what are the tenant's options?
The tenant has an obligation to notify the landlord so that they can make repairs.
And if the landlord doesn't make reasonable repairs in a reasonable time, what's the next? There are two other solutions to that.
Yes, so the other option would be repair and deduct if they're in the position to be able to do that.
That's fine.
And then obviously they can seek to terminate the lease if the living conditions are uninhabitable.
And did your client do any of those, take any of those options? I'm assuming that they notified the stewards and they didn't respond in a timely manner. So we'll take number one off the table. Did they repair and deduct?
You want to write out of state business?
Your Honor, no.
Right now.
Romani's phone, please, 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 please keep yourself on mute. You have a lot of background noise. Okay,
No,
so they didn't repair and deduct and they didn't terminate the lease.
Well, until as of late, Your Honor, they did provide their intent to move out the property because of the issues.
Are they still in the property?
They're in the process of moving out, Your Honor.
Okay. I understand the claim. I don't understand how I'm supposed to find in your favor. Because I'm assuming taking everything as true. They brought a plumber out. They notified the stewards. The stewards didn't respond in a timely manner. And then they didn't do what they were supposed to do. So again, as a judge, I'm not here to reward poor behavior. People come in, they do what they're supposed to do, and that's where I can give relief. But if people do whatever they want to do and then want to come into court and argue about it, I'm going to deny those claims every time.
Right.
We're not, this isn't Judge Judy or any of these places where people just come and they just get to talk and yell and say they're upset. I had pre-issuance yesterday. A guy wanted me to put the mechanic in jail because he took his car to a shade tree mechanic and the mechanic didn't repair the car in time to his liking. And he was upset, filed a pre-issuance. He wants the mechanic to get put in jail. So, and I'm cutting you short because I have a lot of people and I have a calendar this afternoon and I can't just sit here and just listen. I have to try to take control at some point. So I don't see retaliation. Even if Mr. Stewart said he filed this because of the code enforcement issue. Because there were problems to the house that apparently he had to pay to fix. So why shouldn't he seek to recover on those claims?
Well, Your Honor, the retaliation claim is based on the fact that he filed this case, this lawsuit, in response to the Clayton County Code Enforcement. I mean, it's not saying he can't ever file a complaint to seek damages from the home, but the fact that he filed this case after the code enforcement complaint, that was a protected activity. And it was designed to punish my clients for trying to protect their rights as tenants to get repairs done in the home after they repeatedly refused to do so.
And your clients had 3 options available and they only chose one. Am I wrong in that?
No, Your Honor.
Okay. So, Ms. Edmonds, unless you have something else, I'm gonna dismiss this counterclaim.
No, Your Honor, I don't have anything other than the evidence that I plan to present today. Like I said, we do have extensive evidence, but based upon.
नहीं कोई बात नहीं 11:30 तक आओगे
I'm sorry, this is the Zoom Chronicles thing happening. And I'm saying that because I think I've spent an hour on this case already. And I still have 3 or 4 other trials to go. So I'm trying to cut to the chase and see if there's something that's actually there. I understand your clients had to go hire a lawyer. And you've done a great job here today. But I'm not gonna reimburse them for legal fees. Because I, as I said, I see there were avenues that could have been taken that were not taken. Just like with Mr. Stewart and Mrs. Stewart, they had the right to come on their property once a month to inspect it, and they chose not to. And so they're placing the blame on your clients when actually it was something they didn't do. And so with this counterclaim, your clients are in the same position. They're trying to take their non-action and place it on the stewards. And that's just not how the law is designed. Everybody has to take reasonable steps to protect their interests if they deem it to be valuable. And if they don't, they can't come to court and say, protect me from what I didn't do. Okay, so I'm going to dismiss this counterclaim And I'm going to allow you all to be dismissed.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome. Okay. Did we have, I thought, Miss Mary, I heard that there may be an announcement from Mr. Busey.
We were not able to reach an agreement, Your Honor.
Okay. All right, so trying to stay in order. Don't have to go backwards. All right. Next case, I'm calling this position 3, JP Morgan Chase Bank versus David Moody. Mr. Moody is there. And Mr. Busey, this is your case, correct?
Yes, Your Honor.
My notes indicate that this case was filed on August 23rd, 2021. The answer was filed October 15th of 2021. And court notice sent out February 2nd, 2022. So, Mr. Busey, can you please, do you have any other witnesses that you're intending to call?
No, Your Honor. On what was filed in the complaint through that 902 affidavit.
Okay, so can you just, for the record, state your claim in a succinct manner? What are you asking for, and why do you think your client is owed that money?
Yes, Your Honor. I'll certainly be brief after the court's time. So this is a claim on a credit card debt Mr. Moody had with the client. To prove that claim, we have attached with the certified 902 affidavit the charge-off statement when the account was charged off and the balance became due in full. That amount was $13,115.05. My client is not seeking court costs and is not seeking judgment interest either. COVID, respecting that.
Hold on one second. Mr. Hutchinson, are you in the courtroom with Mr. Moody?
Lieutenant Ahmad.
Okay. I'm getting some feedback coming from that laptop. Is it possible to maybe turn the volume down just a little bit?
Yes, Judge.
Okay, thank you. I'm sorry, Mr. Busey, that was 13,000. You said 100 and
$15.75. Yep.
Okay.
13,115.75. And we are not seeking court costs or post-judgment interest. And with all that's going on with Corona, my client has decided to make that switch and not try to get every last dollar out of people. So we'd just be seeking that principal balance that is supported by those statements.
Okay, assuming I find on your behalf, is there any thought given to placing Mr. Moody on a payment plan?
And we did discuss that, Your Honor. We weren't able to reach our guidelines before a suit, certainly, but we will have more flexibility afterwards as regards to his ability to pay back. And I think it's something where he just wasn't able to make those large monthly payments that would be required due to the sizable balance on the account. I did provide him with our phone number though, so I anticipate his being able to call in when he figures out what works best for him.
Okay, Mr. Moody, are you challenging anything that Mr. Busey said?
Requested a copy of the original agreement and all of that, and I haven't received it. So I don't know. And a lot of this stuff on here, I don't know what it is.
Can you explain that further when you say, I don't know what this is?
Well, I didn't see a copy of the original agreement.
I heard that part. I'm talking about, you said the rest of this stuff here.
Oh,
I don't know what it is.
I never exceeded my credit limit on anything. And normally when you exceed the credit limit, you have to get it approved or something. But I don't know what this is about. And
Mr. Moody. Okay, so this is a court of law and you're here defending yourself. So when you say, I don't know what this is about, I can't respond to that. So either you had a credit card from JP Morgan Chase Bank or you didn't.
Judge, can I request a continuance?
A continuance for what?
To get somebody to look at this information, because I don't know what it is. And I never received some of it.
Okay. Are you talking about credit card statements?
I'm talking about what was the original agreement, when it was, and I never lived in Atlanta. I mean, for 30 years. That was mentioned in other things. So I want a continuance to have somebody else to look at this with me.
Have you spoken to Mr. Busey before today's date?
No, sir.
Mr. Busey, have you spoken to Mr. Moody before today's date?
No, we attempted to call several times, but there was no answer on those calls.
Okay. Mr. Moody, a court is generally reluctant to grant a request for a continuance on the day of a trial.
Yes, sir.
From my notes, a notice was sent out on February 2nd. When did you receive the notice to come to court?
One day last week, the lady from the court called me, and I explained to her in the hallway today. I actually got a notice a few days later, maybe Thursday or Friday. It was laying in the street, and I told her I just so happened to pick it up. I had that discussion with the lady up front this morning. But she called me one day last week. If I could check my phone, I could tell you whatever date it was. But it wasn't long.
The notice was laying in the street in front of your house?
It was laying in the street, and I just so happened to pick it up. I said, well, what is this?
Listen to me. Was it laying in the street in front of your house?
On the other side of the driveway, like this house and that house. It could have been anybody's house, but it was not only that notice, it was several other pieces of junk in the street as well.
So it's your position that somebody went into your mailbox and took your mail out?
I wouldn't say that, but I would say probably the mailman running late, because I seen him last night at 7:03 or 7:05, just running late. He may have accidentally done it. I don't know. But the lady called me from the court.
Hold on, Mr. Moody. Let's stay on this thing about the notice being in the street. Was your other mail in the street?
Yes, some black flyers and some junk paper.
Did you have any mail in your mailbox on that day?
I don't think so, but
Before I get down this path, Mr. Busey, what's your position on his request for a continuance?
So I can't join in the request, Your Honor, just because that's not in the best interest of my client at this point. If he's saying he may need time to get more funds, I don't know if that'll make a difference, to be honest, but we leave it up to the court.
What I would desire is that there's a conversation between the two of you about this. I know you met in the breakout room. Mr. Moody, you need to understand that I hear every day, I don't know what this is about. Then when I start engaging the person in the conversation, they know what's about. They're saying they don't know what's it's about because they don't want to, they think that that somehow is some legal justification or some legal defense to say that I don't know what this is about.
And Your
Yes,
Honor,
sir.
when we spoke, we were very far apart. I think would be an accurate way of characterizing it. I don't think it's something that more time would lead to being able to reach an agreement, unfortunately. I did max out my authority and we weren't even close.
Okay. I'm gonna keep moving forward, Mr. Mooney. The amount requested is $13,115.75. And this is on an account. When was the account opened?
It was opened in 2016, the very end of 2016. And Mr. Moody in his answer did request a validation, and we did send that to him with the statement history.
Did you receive that, Mr. Moody?
I received some papers, but I requested the original statement and all, and I didn't open no account in 2016. That's a fact. No accounts in 2016.
Do you have proof that there is a account opened up in a fraudulent manner under your name?
No, sir, but I didn't open any credit accounts or anything in 2016, 2015, nothing of the sort. And that I asked them where, if they got an original agreement stating 2016 or whatever, because I didn't open no account in 2016. And I've never had an account come to wherever they sent this information at. All my life, I dealt with a certain address.
Did you contact the police and notify them?
No,
that-
sir.
Do you think that would be beneficial?
I thought they would send me a signed copy whenever I opened an account in 2016 or whatever the date they alleged it to be. And I'm waiting on that.
You can open accounts over the phone nowadays, Mr. Moody.
I did not open any account on the phone or anything else in 2016.
So that leaves two choices. One, somebody's opened up accounts in your name in a fraudulent manner where you need to contact the police, or JP Morgan Chase picked you out of the bunch and decided they're going to sue you for $13,115.75.
Like I said, sir, I didn't open an account in 2016. I would like to see whatever information on the application or whenever, if I submitted any application for anybody in 2016.
We're not going to just limit it to 2016. Mr. Busey, do you have, I know you said you sent the paperwork to Mr. Moody. Do you have the ability to send the paperwork again to him?
We when we get a validation request, we send everything, and that was all sent to him. We didn't hold anything back. I think the only thing he's looking for is some signed application, which just wasn't applied for as the court indicated. He'll be American Express is very clear that use and retention of a card is sufficient to form a contract. And I think he's looking for something that doesn't exist, to be honest with the court.
Mr. Moody, can you point me to a legal requirement that before I render judgment, I have to see a document with your signature on it?
I don't know anything about the law, but I do know that there had to be, if I got whatever credit card from wherever, it should have been an agreement. And I have never done anything verbally, electronically, anything else. And that's why I asked for a continuation to try to understand this. And when we talked, he said that he wouldn't stand in the way of a continuation or whatever.
Can I ask you what you don't understand, Mr. Moody?
Pardon me?
Can you explain to me what you don't understand?
Oh, and if you buy something, it's got to be an agreement somewhere. If you get something and they say, well, you got this card and all of that. And all I asked for was the verification, the information that proved that this is me. And that, because I know I never had no $13,000 balance on no Chase call, Chase Paper Mark.
Okay. My understanding is that they said they sent the documentation to you.
They didn't send no.
And
no
you said you
signature.
received some papers.
Yes, sir, but not a signature of a signed application. I looked through that all the
Okay,
time
let's
to see what
stop,
it
let's stop. Unless you can point me to a legal requirement that there's a document with your signature on it, please stop telling me that that's what you want to see. Because you've said it at least 4 times now.
Yes,
I
sir.
understand that's what you want to see. I've had the conversation with Mr. Busey and with you about the requirement that something be signed. Okay?
Yes, sir.
So, can you point me to a legal requirement that what you're asking for has to be supplied to you before I render judgment?
No, I cannot. I'm just inquiring about it to see, and I put it on the paper when I filled it out to see when and what was the original agreement.
So the papers that you received from Mr. Busey, what did you learn from the paperwork that you saw?
Like, again, I've never owed a charge.
No, sir, that wasn't my question. You keep asking for stuff and you were given stuff and you said you don't understand. What was your understanding of the papers that you received from Mr. Busey? What did they say?
Well, when I looked at the papers, it was a lot of copies of some stuff, but a lot of stuff that I don't even have no idea about. And not only
No
that,
idea, meaning you're saying that somebody did something fraudulent to you, or no idea because you just don't understand what's on the paper?
I don't recognize. And like I say, I requested some more time or continuance so I could understand or get this in the hands of somebody that may can.
Mr. Moody, I'm trying to work with you, sir.
Yes, sir.
I really am. So if I grant a continuance, how do I know that you're gonna have any greater understanding?
I'm gonna try to get some legal aid or something. I haven't worked for a few years now. And I'm gonna try to get some legal aid or somebody to look at this stuff with me and
So
explain.
if you don't get the legal aid and you don't get anybody to look at this with you, what's gonna happen?
Then I'm gonna go to YouTube and the library and somewhere to study on my own.
Did you go to the YouTube and the library in between requesting the validation information and getting the validation information?
Because prior to that, I wasn't aware of all of this going on. And like I say, I wasn't even,
Did you try to get legal aid after getting
I've
the
called
validation?
around, but I've never been able to get nobody on the phone. I've been holding on from Clayton County, send me down to Atlanta, and I've been holding on. And for whatever reason, I hadn't been able to get no legal aid yet. But hopefully I qualify for it. I don't have a job. And I need somebody to explain to me something.
And we did send a demand letter in this case back in June of last year, Your Honor, just to be clear.
Did that end up in the street also, Mr. Moody?
Well, I don't know. The first time I was aware of this is when the sheriff came to the house, because I never gotten mail, to be honest with you, at that address, period. And I don't even know why they tried to attempt to contact me, because I've never used that address for nothing.
So I'm gonna
Except when the
go.
court started sending me the stuff, then I put it back on the address that the sheriff brought it to.
So, Mr. Moody, it sounds like you're trying to make a claim that somebody fraudulently got a credit card in your name.
I'm not saying that. I'm saying that I need time to study.
Oh, you have had time to study, Mr. Moody. Today is the time for court. I'm saying that to you, sir, because I have not, and I'm engaging in this conversation because I'm trying to determine whether it'll be fruitful to grant a continuance, and I haven't heard that yet.
I believe it
I've
would.
heard a lot of trying. I'm gonna try.
I believe it would. And I talked to Mr. Bussey a minute ago, and he said he wouldn't object to it.
And to be clear, I haven't
In fact,
objected.
he suggested it.
I just stated that we can't join in the continuance, which is what I stated I would do. I've certainly not objected to it, but I stated I leave it with the court because I don't see the fruitfulness in it either.
So, just so you understand what Mr. Busey just said is, hey, court can rule how the court's gonna rule. Based upon what I've heard from you, I don't believe this is gonna be a valid or fruitful situation. Meaning all I've heard from you, Mr. Moody, is double talk. And I'm just trying to be honest with you. I just heard double talk. And you have to understand that as a judge, I hear that every day.
Yes, sir.
I have not heard a serious, in my opinion, a serious statement come out of your mouth that if I grant a continuance, anything different is going to happen. And you're just not going to show up again. I wasn't able to get somebody to sit down and talk to me about this. So I still don't know what's going on.
Well, I show up again, and hopefully I have an attorney with me, somebody to represent me, because I can't.
Hope and try. I am not aware of.
Well, I'll go out and hire an attorney some kind of way.
If you can hire an attorney, you're gonna end up paying more money. If this claim is fraudulent, you need to call the police and report it as a fraudulent claim. But if this is true and accurate, you're committing a felony if you call the police and report this, knowing that is true and accurate. So I'm just saying the fact that you are basically saying, I don't know anything about this, and you haven't taken any steps to fix this matter, says to me that you know that this is true and you're just being very careful in how you're responding to the court, which is wise because you don't want to say something to me that's not the truth.
And I need time. Like I said, I got this notice. The lady called me from the court sometime last week, near the end of the week, to come on the on today, whatever today's date is. And really and honestly, I didn't have time to look through all of this stuff. I studied as much as I can, but I'm still trying to get some help.
What day did you get the phone call?
I really don't know, but I think it was either Wednesday or Thursday of last week. I know it was last week. I don't know the exact date.
And you don't work, correct?
No, sir, I don't have, I'm a senior citizen basically.
So you don't work?
No, sir.
Okay. So what did you do on Wednesday, Thursday, Friday, after you got the phone call about this?
I tried to look up stuff on my own, on the phone. And like I say, the court date was so close. So
You tried to look it up on the phone. Did you call the number for the
I
plaintiff?
called the legal aid several times. But like I say, you hold on all day and they from one place to another, and I hadn't been able to get no help from them.
Yeah, I think your chances are slim in getting help from them. Did you contact the plaintiff?
I've never contacted the plaintiff. The first time I've ever spoke to the plaintiff was today.
Was there something preventing you from contacting the plaintiff on Wednesday, Thursday, or Friday?
Not understanding the procedures properly.
Okay. Mr. Moody, I just don't trust what you're telling me. You tried to do some research on the internet. You didn't contact the one person that could assist you, but it sounded like at some point you did, because Mr. Busey said they sent the validation information over to you.
Well, that's something I got from the court, and I responded. I responded from the court, and I guess the court contacted them.
Mr. Busey, did you send the validation information directly to Mr. Moody?
We did, Your Honor.
Do you know the approximate date?
That was sent on the suit was served October 22nd, 2021. We sent the validation on November 16th, 2021.
Did you just see how that worked, Mr. Moody? I asked a direct question and I got a direct answer.
Yes, sir.
And I've yet to get a direct answer from you.
Like I said, the sheriff brought the notice, and I came to court, to the courthouse, talked to the clerk, and wrote some responses in it. And they sent it wherever, but I've never talked to this gentleman to today.
Okay. Mr. Moody, your request for a continuance is denied. What evidence do you have to put on as a defense in this matter?
Well, like I said, I never over extended any credit limit. And all of these charges they got here, when I looked at some of them, I don't even know what it is. I don't know what it, I don't know. The most
Okay.
that I've ever had an account with, it wasn't no $13,100. And I see
That's-
somewhere they say I exceeded a credit limit. And normally, for my creditors, you know, you have to get approval. And prior to this coronavirus thing, prior to whenever my credit was A1 from everybody, but all of a sudden, I'm at the end of the rope and it's destroyed.
Okay, so is there anything else, Mr. Moody?
No, sir. If I can't get them continuous, because I need it, no, sir.
Okay, well, you're not going to get a continuance. What you need to understand is that mistakes happen. People's accounts can be opened up in a fraudulent manner. People like Mr. Busey, they have an ethical duty to make certain that whatever they're seeking, that they have the proof. And that's why they double check everything, because that can be an ethical issue. I have not heard anything from you yet that would lead me down the path of believing that this is a situation where there is a card opened up in your name by someone in a fraudulent manner. If you have that proof, you can show it to them and they will not be entitled to recover. But so far, it sounds like something happened and you're saying you don't know and you haven't taken the necessary steps to find out. So I'm going to rule on the behalf of the plaintiff. They enter a judgment of $13,115.75. Mr. Busey, I'm going to ask you to send over judgment form to my judicial assistant, Miss Mary, reflecting the information that you told me, and I'll sign it. Mr. Moody, if you're able to present any kind of evidence that this is fraudulent, you need to contact the police, make a claim, and show it to Mr. Busey. Okay, sir?
And I did provide them with our phone number just to make sure that's very clear and there's no doubt about that. What's the best email address to send that judgment form to?
Miss Mary,
I'm gonna message him. I'm gonna send him a chat right now, Mr. Busey,
Thank
with
you.
my email address.
Thank you so much.
You're welcome.
okay, Mr. Moody, you may be excused, and Mr. Busey, after you get the information you need, you may be excused also.
Thank you very much, Your Honor.
You're welcome. Okay, looks like the next case I have is Rashida Hamilton versus Bulldog Insurance Company.
Yes, sir. How are you?
I'm doing well. Miss Hamilton.
And I'm Your Honor, I apologize for muting and unmuting. I apologize.
No problem. Miss Hamilton, are you there where you can hear me?
I am, Your Honor.
Okay, I need you to turn your camera on.
Okay, give me 1 second. How do I do this, Lord?
So, Ms. Hamilton, looks like this civil lawsuit was filed on September 22nd. There is an answer filed on October 15th, and a court notice was sent out on February 2nd. Have the two of you spoken about this matter?
She called me stating that she didn't know why I sent it to her, that at first she said she didn't write policies for state auto. Then she said she did write policies for state auto, but she didn't have anything to do with this. Prior to me filing this claim, I did do some research. State auto is not a local insurance entity here in the state of Georgia. They only have companies that write policies for them. So I was told, I asked the courts, what would I do? And I was told that I could file for someone who writes policies for them, since they're not located actually here in Georgia. So when I was explaining,
hold on, Ms. Hamilton. I'm going to have both of you please raise your right hand.
Okay.
Miss, is it Rumana?
Yes, sir.
I'm gonna need you to raise your right hand.
Yes, sir.
Do you swear affirming the statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Do either one of you have witnesses here today?
no, sir. I didn't know how to go about. When I got this, it was nothing on it to say how I could join my witnesses in.
Sir, can I have another agent as a witness for Bulldog Insurance?
Is that person on the line now?
Yes, sir. Asfar, are you on the line?
Yes, I'm on the line. Yes, Your Honor, I'm on the line. I'm an agent with Bulldog Insurance.
Okay. I need you to raise your right hand also, sir. You
Yes,
swear
sir.
affirming the statements you make during this proceeding shall be the truth, the whole truth, so help you God.
So help me God. I do.
Okay. I'm going to place you, Mr. Is it?
As far.
Well, I'm required to call people Mr. or Mrs. So I just want to know how to pronounce your last name.
Huck.
Hock. Okay. Mr. Hock, I'm going to place you in breakout room number 1.
Okay.
Since you're a witness. And I'm going to come back to you when we need you, okay?
You got it. No problems.
All right. You should see a link or something where you can enter the room.
Judge, hold on one second. Deputy Ahmad, can you hear me? Deputy Ahmad?
I think he's
leaving
walking out.
Yeah, he's leaving out now. I just wanted to tell him we were done for the morning.
Okay. I can just remove that computer. Oh, okay. That worked. Okay, so let me try to cut through this a little bit. Ms. Hamilton, you're making a claim on an insurance matter.
Yes.
And you believe that Bulldog Insurance should be responsible.
No, I don't want them to be responsible. The only way, from what I was explained, the only way that I can get to the insurance company, because they're not here in Georgia, I would have to issue this against someone that writes policies for them. Bulldog Insurance, they're just the writers for the policy, but they don't actually cover the policy.
Sir, can I say something?
Yes, ma'am.
So Bulldog Insurance is an agency, and we do not have a contract with State Auto. So she's not my client. I have no information on her, and I don't have a contract with State Auto. So I don't know how I can represent her.
Does Bulldog Insurance have a contract with State Auto?
No, sir, we don't. We don't have any contract with State Auto. I do not write with State Auto.
They must have recently stopped because I called personally myself,
No, sir.
and
Hold
I
on,
spoke,
ma'am.
and she told me herself when she found out what it was about and she called my phone, she told me herself that she writes policies for State Auto. I'm not just gonna go and choose you out of a pile if the information wasn't verified. You, before even speaking to you, I called your insurance company myself just randomly to see if you guys wrote for State Auto, and someone said yes. And then when you reached out to me yourself, you told me yourself when you called my phone to ask me about the situation, you said you wrote for State Auto.
Okay, can I respond? Your Honor, can I respond?
Yes, ma'am.
Okay, no, sir, I did not say that to her. No one in my office told her. In fact, we told her right away, we do not write with State Auto. We do not have a contract with State Auto. And that it was a waste of time. It was a waste of her, I told her, I said, I know my contract, sir. I write with 40 other companies, but I do not write with State Auto. I do not have a contract with State Auto. But she insisted that someone told her that we were one of the agencies that she could list. I don't know how I can help her.
Okay, Miss Hamilton, when did you write or obtain this policy?
Ooh, back in 2018.
And have you been making payments monthly on this policy?
Yes, I stopped making payments on the policy after they denied the claim and the car was inoperable.
Okay. State Auto denied the claim.
Yes.
How much was your policy for? I mean, monthly.
My monthly payments was $335, I believe.
And where did you send the money to? To whom did you send the money?
State Auto directly debited from my checking account.
When you obtained the policy, how did you obtain the policy?
When I got the car, one of the salesmen at the lot had a list of agents that one of them that I spoke with by phone to obtain the policy. But after obtaining the
hold on. So you never went into Bulldog Insurance Company?
No, sir.
When you call the person to obtain the policy, how did they identify themselves?
To be honest, Your Honor, it was so many years ago, I don't remember.
Well, ma'am, you're gonna have to. I'm not, Jesus. I just can't figure stuff out.
I totally understand. My question to you is, I'm not going after the agent. I don't have an issue with the agency. I have an issue with the insurance company. But because it's not a local insurance company, I'm told to file the claim against an agency that writes policies for them. Is this not the correct protocol? Or because my issue is not.
I haven't heard proof that you contacted Bulldog Insurance Company to get the policy.
No, I did not obtain a policy through them.
Okay.
But this is what I'm saying. The instructions that I was given was not stating because I had to file the claim in the county that I live in. They said I had to file the claim through an agency in that county that represented State Auto Insurance. I live in Clayton County.
Okay. So you've never spoken to anybody from Bulldog Insurance Company. You're just filing this claim to try to get to state auto.
Yes, sir.
I don't think that that's proper.
Okay, this was the protocols that I was given. So how do I
I
get
can't
to them
advise
if
you.
they're
I can't advise you.
wow?
That's where lawyers come in.
And even a lawyer, this was the instructions a lawyer gave. Like okay.
So I have to determine that there's some type of relationship between you and the defendant. And it doesn't appear that there's...
Well, I don't have a relationship with them. I'll be honest about that. I don't have a relationship with them.
And I believe you that you are being honest with me. So generally what happens, so you're talking about a business, every business has a registered agent. If state auto is doing business in the state of Georgia, they should have a registered agent that you can determine that information by going through the Secretary of State's office. And the appropriate thing to do would be to notify the registered agent of your intent to file a lawsuit based upon whatever claim that you have. The registered agent gets paid by the company to register to represent them. And you may have to go to where the registered agent, whatever county the registered agent is in, and go through that process.
Okay.
All right. So I'm going to dismiss this claim for lack of improper parties. Two of you can be released, and I'll bring Mr. Hawk out.
Okay, thank you.
Thank you. Thank you, Don.
Please. Yeah.
Thank you.
Doesn't look like he made it back in.
Hello?
Mr. Pasfar,
Yes, ma'am.
parties have been excused, so you can leave now.
Thank you.
You're welcome.
Okay, the next, yes, ma'am.
He came back on. I told him he was free to leave.
Okay.
Okay.
As soon as I joined the room, he clicked
Yeah.
Clicked over. All right, the next case is position number 8. Export truck sales, Michael Ifani versus alternative rental. And I see Mr. Robert, what's your last name?
Dean?
Dean, Mr. Dean. Okay. And Michael, I need you, or Mr. Ifani, I need you to turn your camera on.
I thought okay. I didn't know that it's not on, Your Honor. Sorry.
No problem. Can I ask the two of you to raise your right hand for me, please? Do you swear affirming the statements you make during this proceeding should be the truth, the whole truth, so help you God?
I do.
Okay, so this is case number 2021 CM 17165. Looks like the lawsuit was filed in October of last year. Answer was filed October 15th. And so I can notice trial was sent out on February 2nd. So, Mr. Ifani, please.
Yes, Your Honor. On July 29th of 2001, after we agree with alternative rentals, they delivered me a piece of equipment. On the piece of equipment, we rented for 1 week. The time arrived was July 29th, and we should return it August the 5th. By the rental agreement on 11 o'clock. Before they delivered the equipment, before they unload the equipment, they ask for deposit checks, which is I wrote the checks and give it to them. And the check was posted August the 2nd. Your Honor, after the equipment arrived, I saw some damage to back of the equipment. And therefore, I asked the gentleman that he was delivering it. He says that has nothing to do with the mechanical. But as every piece of equipment we rent, I took a picture, 4 pictures on each side of equipment. You must have, we send it online, Your Honor.
Mr. Ifani.
Yes, Your
Honor. Can we cut to the chase a little bit?
Yes.
What is your claim?
My claim is we only use the equipment 1 day and the equipment start overheating through mechanical issue. And it was, they delivered Friday, by Saturday we used it and we saw as an issue. We call them by Monday, they come pick it up. They're supposed to take it, fix it, and bring it back. They told us we might fix it themselves or take it to somewhere else to fix it. So we expected another week or so. We waited a week, we call them. They said, no, it's not fixed. Week 1, 2, 3, it didn't work. So we assumed that they're never gonna deliver it. They bring it back to our systems or whether they can fix it. On August 19, I send them a demand letter. On the demand letter, we ask to return the 1 day use that we have minus that, which is would be 1,200 for the rest of it. And they didn't do any of this. Although I spoke to Mr. Dean a few times, and I mentioned it that I don't have no other options that goes to the court. And he didn't care. Therefore, I'm right in front of you, Your Honor. The vehicle was properly run. The picture that they sent in the counterclaim, I can see it. The picture was taken October 15th, Your Honor, as I highlighted. This and the picture that I took, and I have evidence on my phone, the date, time that his driver was delivering it, sit it on it, and the damage was there. The damage of the back of the equipment was there already, and we highlighted there for evidence.
Okay, hold on, let me ask you this.
Yes, sir.
So you're saying that you rented this piece of property for a piece of equipment for 5 days?
Yes, yeah, for a week generally, yes.
And you only got 1 day's use out of it?
Correct, Your Honor.
And so you're asking for the return?
I'm asking for the return or use of one oven, because if it's $1,400 divided by 6, we come up with $1,020.
Hold on a second.
Yes,
Because
Your
the term of the rental was 5 or 6 days.
That's correct.
No, I'm asking.
Yes, we rented for 1 week. That's why we give them the $1,400.
You said 6 days.
Maybe 5 or 6 days. It's the Warbler agreement was a week, and on the contract says we need to return it, or they come pick it up by August 5th. From July 29 to the August 5th, whether it's 6 days or 5 days, Your Honor, I can look at the calendar and tell you. But clearly on the,
I think that's 7 days.
it could be.
Hold on, sir, please. Let me ask you some questions so
Yes, Your Honor.
I can understand. The lease term was 7/29 to 8/5.
Correct, Your Honor.
Were you to have it at your place on 7/29?
Yes, Your Honor. They delivered it on
And
Sunday.
all right, so we got 7/29, 7/30, 7/31, 8/1, 8/2, 8/3, 8/4, 8/5. I count 8 days.
This is the way they wrote. I did not. We agree on a weekly, and they wrote it on the return day by that. But we did not get chance to use it more than 1 day.
I heard that pretty clearly. That's where I'm trying to drill down into this.
Yes, Your Honor.
So what was the daily amount?
This is how I calculated it.
It's not in the agreement?
It on agreement, it says $380 a day. Yes, Your Honor, it is.
Okay.
I'm sorry.
$380 a day.
Correct. And
Thank you.
yes, Your Honor, I'm sorry.
And so you're asking for a judgment in the amount to reflect that you paid the entire amount, correct?
Correct.
But you only got to use the equipment for 1 day.
That is correct, Your Honor.
So we subtract 1 day away. And then by my count, that's 7 days.
You're right, but like I said, whether the Sunday or Saturday count in it, that is the question. The Sunday doesn't count. And on the agreement is the equipment is daily $380, weekly $1,330.
Okay. Okay. I'm gonna pause you right now because I want to go to Mr. Dean
Yes, Your Honor.
and see what his response is. And first, Mr. Dean, was there a contract entered into?
Yes, sir.
And did the vehicle or the equipment become unusable after 1 day?
Yes, sir.
And did you come and pick the equipment up?
Yes, sir.
Did you refund any monies to Mr. Ifani?
No, sir. I expect he owes me more. And the reason I picked it up, the reason the machine became unusable was what I can only consider a crash, a wreck. The machine was damaged in the back, in the area where the engine compartment is. There's a radiator, air cooler. I've got a 3-page list of what the dealer repairs. And this is just the first page. You can see it's quite a list at the bottom. And
Let me ask you a question because I have to deal in sort of concrete matters. How much did it cost to repair the vehicle?
$14,580.84.
You said 14,000?
Yes, sir. Extreme damage. The machine
Okay.
cost new about 60,000, and it was less than 2 years old. It has 400 hours, which if you were driving a car, that would be about the equivalent of 20,000 miles. So not an old machine.
Did you make a demand for payment to Mr. Ifani?
No, sir. I felt it would be pretty harsh for him to pay for all that damage. So what I did was, and I told him this at the time, was I made a insurance claim. Got my copies of that too. Insurance paid all of this except for the 1,000 deductible. And I've got a receipt for the 1,000 deductible. Got a letter from the insurance company stating that there was a claim. And that's why I didn't give him the refund, because what I had left out of the 1 day rent was close to 1,000.
So it's your belief that Mr. Ifani damaged the equipment?
Yes, sir. It was, he used it the first day and it worked just fine. The second day, it sprang a leak of antifreeze and hydraulic. And the reason for that is the wreck that it had. I would say either this thing is self-propelled, it's capable of about 9 miles an hour. So, and when you're operating it, it's like a bobcat. Called it skid steer loader, but most people call it a bobcat. You drive forward and you do your work, and you back up to get another shot at it. And in backing up, if you hit something, the machine weighs 9,500 pounds. If it hits something, it's a hard hit. And either that happened or possibly there were a lot of tractor trailers on the yard. In fact, that's just about all that was on the yard. And one of those could have backed into it when it was not being operated and done the damage. But either way, it didn't have that damage when he got it. And when he called me and said it was leaking, I went over there and it had great damage.
Have you seen the pictures that Mr. Ifani said that he took of the equipment when it was delivered?
I had not seen them until just now when he flashed one of them. I have pictures of the damage. Also have pictures of the parts that were replaced.
Have the two of you spoken before today's trial?
When I went to pick it up, I spoke to him then, and I told him, I pointed out the damage, and he was quiet. And I explained to him that that was what had caused the problem, and that I would take it home and take it back to where I work and see if I could fix it. But when I got back, I talked to my mechanic and we looked at it and thought, this is going to take a whole lot to fix, and it's more than we can do. So we're going to take it to the dealer, have the dealer fix it and make an insurance claim, because knowing it would be a great deal more than the 1,000 deductible. And he called the next day and asked, were we able to fix it? And at that point, I explained to him again, there's great damage, and something hit it or it hit something, and that I was going to have to take it to the dealership. And both times he made no reply as to the accusation of him having done the damage, just no reply. And so later on he called, I missed his call, and I put off calling back for 2 or 3 days, and then the letter came. So I replied to the letter quickly, like within a couple of days. That's quick for me. And in my reply, I asked that he pay for some other things that went along with it that wasn't part of the actual accident. He was using an attachment on the machine called a Forster grinder. You know what that is?
I do not.
Okay. It's you take the regular dirt bucket off and you put this machine on there, and it grinds much like a stump grinder.
Okay.
And he had that on there, except his would not fit hydraulically. You couple it up with hydraulic quick couplers, and the ones he had were the wrong size, way too big. So we put our own on, and when he retrieved that from us, we didn't get our couplers back, and they cost $144. And also there's tax on these things. We wanted the 1-day rent, delivery and pickup of $100, $144 for the 3 couplers, and then tax on those things is about $50 more, comes to $274. And that's really all we're after at this point. I thought I was being very generous to give myself an insurance claim that goes against my record, so that all it cost him was, rather than have to pay the $14,000 repair, all he has to pay is $1,000 for the deductible. And that's pretty much my statement. Ready for questions.
Okay. What steps did you take to show proof that Mr. Ifani damaged the equipment?
I pointed it out to him at the time that I picked it up. I said, look, this has been smashed in very far. It's kind of like a box with the engine in it, and you can't tell exactly what happened inside the box, but you could see that the engine compartment was crushed in. And I spoke to him one other time, and when I told him the part about him doing the damage, he made no reply, acted as if I didn't say it. But and then we had the letter, and then he made the claim to the court. So that was our communications.
Mr. Ifani,
Yes, Your Honor.
you've heard what Mr. Dean has to say.
Yes, Your Honor.
And I'm assuming by showing the pictures before of the pictures of what happened or how the device or equipment, I'm sorry, and I'll just say the piece of property, how it appeared, as you say, when you received it. You said you took pictures of.
Yes, Your Honor. I took the picture of it because the damage was so obvious. I took a picture four-way around it. His driver was sitting on it.
Hold on, sir. I'm sorry. I'm just because
What should I answer, Your Honor?
Well, I asked that you say that you took the pictures, and I heard that you had taken it around 4 sides, and you said you did that before or when you received the equipment.
That is correct, Your Honor.
When Mr. Dean accused you of damaging the equipment, did you show him the pictures?
I told him at the time that the damage was already there. He was so aggravating, so unpolitely was there, and even told him that I have it if he wanted to look at it. He did not once. He himself comes to pick it up instead of his drivers and took it. At that time, he wasn't saying that the damage is because somebody there's a damage behind it. It says there's the mechanical. He's going to take it to his place, fix it, and bring it. Therefore, he still took our mulcher with the equipment. The mulcher that is supposed to feed, and he himself feed it off there where it was, the feeding was stood. He take the machines, he could take it off. At the time, it wasn't talking about any damage or anybody responsible. He was saying that the mechanical leak is water, and he's going to take it and fix it. And I look at the picture that he took on October 15th, is the same damage that it's the same damage that was the first day, Your Honor. It's the same, except this picture is black and white. Mine's is clearly color.
Mr. Ifani, do you believe it would have been helpful to show those pictures to Mr. Dean when he came to pick up the equipment?
All honesty, Your Honor, at the time, we were supposedly in a good term. He rented equipment to me, and the equipment sometimes equipment goes a breakdown. We call the rental, and they come sometimes fix it there or service it to take it. And if I would notice it that it will take him, we will go that route, or even later on, I would show it to him.
Okay. So this happens a lot with younger lawyers, where people are so caught in their theory of what happened that they're not willing to sit down with the other side, show the other side what they believe happened and how they can prove it. Somehow it has gotten in everybody's mind that we just go to court.
You're right, Your Honor. Therefore, we mention it. I made at least 6, 7 calls. As he mentioned it, that he called me, I called him, and a few days later, he called and stuff. He avoided my call. And if he would come in out to the term that that is the problems, or if we were going to take it to the insurance company, I have to be responsible, I would show it to their insurance company. I'm assuming is he's fixing it. and if it's damage to it that has to repair it to the insurance company, that's the evidence that I didn't. I'm assuming he didn't want the insurance company have that one, because he already, that vehicle was somewhere else damaged when he delivered it to me. And clearly evidence is the day, the picture that he has, we have it, and the picture that he sent as evidence, both showing the same damage. Before even we touch the equipment.
Mr. Ifani, Mr. Dean makes a good point about the equipment work for one day. And then when it stopped working, it was in your custody.
Yes, Your Honor. May I answer or not?
Yes, sir.
Okay. As operator with a 40 years experience, and we have some machines too. In the morning, it maybe work, maybe in the afternoon, due to the previous issue, it might not carry a damage. The damage, it's not every morning when we crank any equipment. Matter of fact, I was so careful on his machines. As soon as I saw the temperature went up, I cut it. I could run that machines until engine block ceased. I did not. I brought it up nicely and park it over there for him to come and invest his equipment. Now, simply only one day working a machine, it doesn't mean that doesn't have a previous issue. And when we worked on it, when the engine got warmed up, and then it'll affect some problems, and then later on with that. That's my 40 years experience, Your Honor.
I've rented skid steers before for work at my house. So I understand how the machines operate. I'm not seeing that the damage that you observed to the back of the equipment is the proximate cause of the equipment not working on the next day or overheating. Do you have any evidence that the proximate cause of this vehicle overheating was something that was there on the vehicle?
Your Honor, I don't even say that the damage was caused of, that's my point is, the damage, the back of the vehicle has nothing to do with overheating the engines. Overheating engine could be water pump stop, could be lower on antifreeze, all the stuff that they rental service in it and bring it to us and we use it. Same thing as you said, Your Honor. I looked at it, the damage behind it, and I said that same way. I said, well, it doesn't look like this damage would cause of mechanical problems. But because of when we have to return the same vehicle with the same positions, I took a picture, not this one on any other vehicle as well. But and it's my point. The mechanical issue it was previously at that time come up to the point to the end, not by this damage that when they brought it or they took it. You're right, Your Honor. It's the same way. This damage would not cause of any mechanical problem. I agree with you.
Mr. Dean, do you only have one skid steer?
Only one like that one. It's pretty big. I have several that are smaller, but this is the one he needed for what he was doing. It's the only one that would run that Forester grinder.
Is there a reason you didn't either provide him with another piece of equipment or return the monies that were not earned?
The reason I didn't supply him with another piece of equipment is because I did not have one that would do what he wanted to do. I only had the one. And the reason I didn't return any of the money for the rent was I used it to pay the deductible on the repair on the insurance claim. I felt that at minimum, he should be responsible for that. Another thing, going back to the machine malfunctioning, when it ran hot, I thank him for not overheating the engine and cutting it off at that point. That's really expected, but he did that. That's good. He pointed out when he called, he said, it's overheating. I see antifreeze pouring out from underneath the machine. And so apparently the leak was not a small one. So what happened, the damage that happened must have happened just a very short time before that. And as evidenced by him running it the day before with no heating problems. And but the engines inside that compartment, there's 2 radiators, one for the oil, one for the engine, the hydraulic oil, and those were damaged. I have pictures where showing what the repair company replaced.
Mr. Dean, wouldn't the appropriate thing to do in this situation if he contracted with you to provide a service that you were no longer able to provide is to return the unused monies? And then if you believe that he was indebted to you on somehow injuring the equipment, for you to pursue him for that claim?
Well, sir, I kept the money because it would be his responsibility to pay me that money anyway, and to give him the money back and then try to get it back from him would obviously not be fruitless. I've been doing this for 49 years and I know how people react when they damage. They almost always will say, I didn't do that. I'm not responsible for that. But that's what it was. And he did not deserve money back. He deserves to pay for the repairs. I think I shielded him greatly from the $14,000 cost. Got it cut down to only $1,000. It's getting to be a bit much, isn't it? I've watched you this morning. You've had a rough morning.
Well, it's I don't know what's going on in the world today. I don't. If Mr. Ifani contracted with you to provide a service, you either have to provide the service or return the money. If Mr. Ifani did something in your opinion that frustrated your ability to provide the service, he could be liable to you.
Yes, I think he is.
When people start combining things and commingling things, it immediately brings into the court's mind what are they seeking to obtain. And it makes me question the motives. Everybody starts out with a clean slate. The plaintiff has the burden of proof and persuasion. Okay, this is what I'm going to do. Oh, and I'm sorry, Mr. Dean, what was the term? Because Mr. Ifani was saying a week, but what were the number of days that this equipment was supposed to be in his custody?
7.
7.
But our daily rate is not 1/7 of the weekly rate. We charge a rate that's not 1/7. Actually, it's 2/7.
It's higher.
Yes, sir. We charge a daily rate, and then after 3.5 days, we figure they've reached the weekly rate, and then it doesn't get any more for the next 3.5 days. So 3.5 times, $380 times 3.5 is exactly, it's that's no contract, but it's that number that's on there. 1330. That should be it. Actually, we negotiated. He's a skillful negotiator, and I reduced the price that he got it for.
So it was 1330.
Yes, sir. $1330. That is exactly 3.5 times 380. So, and there was also a delivery charge of $80. I would have been able to give him his week had he not damaged the machine. And the damage was such, it took him 3 months to get it fixed at the dealership.
Okay, there's no way for me to determine on either side who's at fault. I'm going to take that 1330, I'm sorry, did you say 1330 or 1300?
1330 plus 80 for delivery.
You know, the property was delivered.
I wrote
So
him a
that-
$1,400 check, Your Honor.
You wrote him a check for how much?
$1,400.
Is that correct, Mr.?
Yes.
Okay. So I'm going to find that Mr. You wrote him a check for 1,400, but you got 1 day's use.
Yes, sir. He still owes me for the couplers. It's $144.
Is there a reason you didn't return the couplers, Mr. Ifani?
Your Honor, the machine, when he picked it up to take it to fix it, it was with it.
It was what?
With the mulcher.
Right.
Yeah, he was with the mulcher, he took it. And then later on, he came by and pick up the bucket. He could, anytime he wanted, to bring the original connections, and we give him his fitting. No, I have no problems. He give us our fittings, we give him his, he can take it off because he has to take it off and put it back in himself. We don't have no problems. Or,
Okay.
or if he
Go
can
ahead.
bring, go ahead, I'm sorry.
No, you go ahead.
Yeah. I would be fair to say if he can bring me the old one, and I'll pay for that if he doesn't want to take it. If he want to leave it the way it is, we just we'll just pay half of it. For him to wouldn't be cost to come to our facility, take it off labor cost. However, solve the problem.
So you say O1, is that the grinder or is that the bucket?
The motor, when it comes out, has a different coupling, which is fit to the machines. So when we want to hook up the motor to it, it didn't work. So they take the motor and the machines back to their office. He put a new coupling, he's right. But he took the old one. I don't have the old one. If he give me the old one, I give him the new one. If he wanted me to pay for a new one, he will give me the old one plus the how much the invoice is, I'll pay for it.
What's your preference, Mr. Dean?
My preference would be to exchange the couplers like he suggested. I would be willing to drive over there and do that. My other preference would be that he pay me the $1,000 deductible on the $14,000 damage that he did.
So what I'm going to do is I'm going to issue a judgment that basically reflects both sides. The judgment is going to be $1,330 in favor of Mr. Ifani, but I'm going to offset that by $1,000 for the deductible. So that's going to be a total award to Mr. Ifani of $330. Okay.
Not really okay, but
I understand.
You say $330. I'll do that in cash. I'll make a receipt and have him sign it, and I'll go over there and exchange the couplers.
Okay. Thank you both. You both are free to go.
Thank you, Your Honor.
Tomorrow.
All right.
You're welcome. So next case is Tara Rucker versus Tony Palmer.
Good morning. Good morning, Judge.
Good morning. And I'm sorry, I woke up this morning and it feels like there's an iron skillet in my stomach. So it's a very unpleasant day. Mr. Dean, is there, okay. I'll just remove you, Mr. Dean.
Thank you. I can't get it turned off.
Okay. So this is abandoned motor vehicle. We're going to start with Tara Rucker. And if you both could, just please cut to the heart of the matter.
Yes, Your Honor, I'd be happy to. Your Honor, on June 10th, 2021, Brackets and Ratchets Auto contacted us to impound a 89 Ford F-150. We provided that service for them. We sent notification letters to the registered owner, which was Tony Palmer, on 6/17 of 21. And I show the tracking number that was delivered to him on 6/22 of 21. And he failed to pick the vehicle up from us. So that's when I filed the petition to obtain an abandoned motor vehicle foreclosure.
Okay, let me swear you both in, please. I'm sorry. Do you both swear affirming the statements you make during this proceeding should be the truth, the whole truth, so help you God?
I do.
I do.
So, Mr. Palmer, is this a
Yes, sir.
situation where you are having a dispute with the owner of the auto service and they had the car towed over to Tara Rucker?
No, sir, that's not this case. What happened, Your Honor, is June. In May of last year, I took my vehicle to Brackets and Rackets to actually have the vehicle repaired and restored. It is a family heirloom passed down by my father-in-law who's no longer here. I wanted to have the truck redone. Brackets and Rackets informed me that they had a long list of vehicles that they were currently working on. The guy wrote up a ticket for my vehicle. I gave him my address, my current phone number, a photocopy of my driver license. He and I agreed that he would give me a call once they came up with a total and we could agree on whether or not I wanted them to fix the vehicle or not. I did not receive a phone call. I did not receive any notice from Brackets and Rackets of any sort. The next thing I know, I received a notice from Terra Record stating that my vehicle had been impounded. During that time, I went down to Terra Record to try to discover what had happened. If I had done something wrong, if the vehicle had been removed or anything had happened, they simply notified me that Brackets and Rackets had contacted them and asked that they pick the vehicle up. I went back to Brackets and Racket and asked those guys what had happened or what was going on because it was obviously parked on private property, which I was authorized to park it there. The owner or the manager of the mechanic shop replied to me that he had no idea what was going on with the tow. And my vehicle has been in Terra Records possession up until this point. I reached back out to Terra Record to see if I could work something out because I didn't want to pay a week plus or 2 weeks worth of storage fee without even properly being notified that my vehicle was there. They told me that there was obviously nothing they could do. I had to pay the fee to get my vehicle removed. I also had left my construction equipment on the vehicle. I couldn't remove any items from the vehicle. I couldn't go out in the yard to the vehicle until the total had been paid in full. So I did nothing other than wait to, come to court. Now I'm being told that they're asking for a total of approximately $4,000 to obtain my vehicle back. And I don't feel that that's, fair to me, or I truly don't know what happened or what's going on outside of that, Your Honor.
So it seems like you just basically said to me what I thought the issue was. So did Tar Rucker show you the invoice where they received the call to come pick up the vehicle?
No, sir, I have not seen that invoice, but I'm going to assume that they had, that they have something where they're told to come and pick up the vehicle, but I have not personally seen it. No, sir.
So what generally happens and I see it often. These auto repair places, if they contact a tow company to come remove a vehicle and they perform that service, the tow company has the right to charge for that service. And if they're not paid for that service and the storage of the vehicle, they have the right to seek to take ownership of the vehicle so they can sell the vehicle and recover. What generally happens, your fight is not with Tar Record, it's with the Ratchet Auto people. Because if you had an agreement with them and they went outside of that agreement and had the vehicle towed, and now you're having excess costs because of that, you can recover from them, but it's not Tar Record's problem. So the way that the abandoned motor vehicle statute works is that counties don't want to have a bunch of tow vehicles where they're towing cars to their lot. So they either contract with people like Tar Record for that service to be performed and that's by the county. But Tar Rucker can also do that as it relates to auto repair dealerships. So unless you show me something different, I'm going to issue an order for Tar Rucker to be able to take ownership of the vehicle. And if the vehicle has that sentimental value to you and you want to keep it, you're going to have to pay Tar Rucker and then sue the auto repair people. Does that make sense to you?
Yes, sir, it does.
Yeah. I understand what you're saying when you're saying, hey, this doesn't sound fair to me. But it is state of the law. When you receive notice, you could have either A, had Ratchet Auto pay you and you pay Tar Rucker, or you pay Tar Rucker and then you go after Ratchet Auto.
Do I still have the legal right to go after brackets and rackets?
Mm-hmm.
Okay.
You do, because your agreement was with them. It wasn't with Tar Rucker. And based upon your testimony here today, they're the ones that broke the agreement.
Understandable, being that I do have to give up my vehicle and understanding that you're going to rule in that judgment. Would Tar Rucker be willing to at least allow me the opportunity or afford me the opportunity if I bring that title over to get my personal belongings out of that vehicle? I have a few $1,000s worth of construction equipment in the vehicle that I would at least like to obtain. Or am I also forfeiting that as well?
No, you're not. You're entitled to that. You're saying no?
He had 30 days to do that under the law.
Did he request? I heard his testimony.
It was over 30 days.
I requested it when I initially went and had the conversation with Tar Rucker and was denied that. So yeah, is at this point.
On what date was that, sir?
After I received a notice in June, I can't remember if it was the 22nd or toward the end of June, but after I received the notice, the first thing I did was come and talk to Tar Rucker. So it would have been toward the end of June, beginning of July. But it would have been before the vehicle was impounded per the 30 days. I was told by the window clerk that I did not have the opportunity to go back to the vehicle without paying for the impound.
You know,
they told me that if I was going to the vehicle to show, no, ma'am, I can't remember the young lady's name, but I can describe her. I have seen her a few times because this is not the first time I've dealt with Tar Rucker. She's a shorter young lady with the short cut hair. Again, I'm sorry, it's been a few months, so I do not know her name.
Okay.
They told me that I would have been allowed to go ahead.
Your Honor, I will allow him 5 days to come and I will extend that and give him 5 days to come and remove his items.
Thank you, Mr. Palmer. You have 5 days to go and remove your items. And Mr. Palmer, you have to understand,
yes, sir.
Tar Rucker is in business to make money. And
I understand, Your Honor.
They never would have had possession of your vehicle had not they received a phone call to come tow it.
I understand. So at this point, when I do, unfortunately, right now I'm in Florida. I'm a truck driver, so I am in Florida. I still will not dispute it. Despite the 5 days, I will make an attempt to get there within 5 days to obtain my property. And also, when I do get there, I'll be reporting down to Clayton County. I don't know. I'll figure out legally if I have to notify brackets and rackets of an intent to sue or what have you. But I will be going after brackets and rackets for the value of my vehicle, based on the circumstances and conditions. So I do understand.
Your Honor, may I ask Mr. Palmer a question?
Yes, ma'am.
Would you have a problem with, since you're over the road, getting here within the 5 days?
I think it would be difficult, but I'll have to find a way to make it happen.
When-
I'm not gonna fight you on the 5 days.
Okay.
Unfortunately.
I'm flexible, sweetheart. When could you be here? When are you scheduled to be through here?
Next week. Today is Tuesday. I would say around next Wednesday or Thursday. I could be there.
Can he have until February 25th?
Absolutely, Your Honor.
Okay, so you have until February 25th to come remove your items. Thank you for being flexible.
Thank
If
you.
would just send that order over to Miss Mary, I'll sign off on it. And
One last question, Your Honor, if I could ask it.
Yes, sir.
And this is not for legal advice, but is there some form of statute of limitations regarding, since this issue happened in June and the matter just took place, is there some statute of limitation that would prevent me from attempting to seek my damages through records and records at this point? I only ask because being a trucker again,
No. I believe you have a year. It's either a year or 2 years, and I'm sorry. I'm maybe getting my statute of limitations, but you do need to provide notice to them of the claim. And if they don't respond or they don't make you whole, file your lawsuit.
Not a problem. One last question to young lady at chair, and I'm sorry, I didn't recall her name.
Miss Chastain.
Miss Tracy Williams.
I'm sorry.
That's okay.
Okay, Miss Ward, Miss Warden. I'm sorry,
Miss
Miss Warden.
Williams.
When I come
Wiggins.
in, Miss
It's
Williams.
Wiggins.
I'm sorry,
No,
Miss
Wiggins.
Williams.
Williams.
Williams. She's saying Williams.
It's okay. It's a little.
All right,
hard
Miss
on
Williams.
these
When I come up there, is it possible to receive what you and I spoke about in the breakout room regarding that total of, I think you said it was close to 4,000 some bucks. Is it possible to receive that in writing?
You should have a copy of that with the that was mailed to you on the petition with the court that you answered to have this court date. Did you get that copy?
I got a copy, but I don't recall there being a total for the for record
There is.
fee.
There's a total on there on that paper.
Okay.
Okay.
I'll attempt to find it.
Miss Palmer, you're free to go, and Miss Williams, you're free to go. Just send that order over to Miss Mary.
I certainly will. Thank you, Your Honor.
Thank you. Last case, 2022 CM 00643, New Image Towing versus Miss Cajito. Okay. So is this a similar situation as to the last case?
No, Your Honor, it's not.
Okay. Let me have both of you raise your right hand, please. Do you swear affirm the statements you make during this proceeding should be the truth, the whole truth, so help you God?
I do.
Okay. New Image Towing, you're the plaintiff. You have the burden of production and persuasion. What are we dealing with?
Yes, sir. So just to get straight to the chase, she is no longer the owner of this vehicle, but when we impounded it and sent the VIN over to Clayton County Police Department Records Division, and it was run through the GCIC system, we received her information back. And by law, we are required to contact anyone who comes back on that information. So that's why she received our letters. She did respond to it. She did let us know that she does not own the vehicle, but since we are not able to obtain any other owner information, we are required to still contact her and list her as the defendant.
Okay.
So the only thing we want from the court is a order to be able to sell the car. We don't expect anything from the defendant. If she's not going to pay for the vehicle, that's fine. We just want to make profit after being able to sell it at a public auction. We won't put anything against her credit, come after her, put anything against her record. We just want to be able to sell the car since there's no owner that's interested in coming to pay us the fees owed on the vehicle.
Sounds reasonable to me. Ms. Quiro?
Your Honor, everything she has said is correct. I would also like to say that I be removed from the public record because, as she said, I am not the owner of this car, and I would not want my name to be associated with a suit in this case. And if possible, to have that removed, because I should never have been named defendant. This car is not mine.
Okay, I can't do that.
And I unfortunately don't have the ability to do that either. Like I said, we strictly get our information, the owner information, from the police department. So whatever they send us back, whether it's the current owner or the last known owner, we have to go off of that information because they weren't able to provide us with any other information regarding who owns this vehicle. So I'm not sure if it was sold or traded in, but it was never re-registered. So we have the defendant as the last known owner, and we are required to contact her and list her as the owner since her information came back.
That's my understanding, Ms. Keogh.
Yes, Your Honor.
Okay. Well, that'll be the ruling of the court. Please send a judgment over to Miss Mary and I'll sign it.
Yes, Your Honor.
Okay, is there anything else on this case?
No, thank you, Your Honor.
Okay. Both may be excused.
Thank you.